Wendy, you and I have been administering trusts for quite a long time, and I think one of the common themes that we've heard over the years is people not understanding what comprises their estate, and also, how do I know if I need a trust? So if we talk about estates a little bit, what comprises an estate?
Well, and I wanted to back up just a little bit. I agree. I think that there is a misconception of what an estate is. We chatted about this before. Years ago when you had a federal estate tax return, 706 is what it was called, it was the whole estate. It was the homes, the investments, the annuities, the life insurance. And so people hear estate and that's what they think it is. So I think it is important that we differentiate between the differences. This is an estate, as you call it, a probate estate, opposed to a trust.
So there's a legal definition and a common practice.
Absolutely. So when attorneys say estate, I believe they're talking about a probate estate. And as we understand it, and we can get into it a little bit more when we're talking about the titling of assets, an estate is assets that are in someone's individual own name. What can comprise a probate estate? House, a car, jewelry.
Personal property types.
Perfect, yes, absolutely. And you're right, there is a differentiation between what's in my estate and what's in my trust. And I think we need to hit on that. When we were chatting about this previously as well, we found out an interesting statistic, and it was 55% of Americans do not have an estate plan of some type, which is somewhat shocking.
So no legal documents?
Absolutely.
So what legal documents does every person need?
Well, we think as we deal with our partners, attorneys in town, we feel that you should either have a will or a trust. Important to have a power of attorney. Important to have a living will, if you so choose that that's important to you, a healthcare surrogate, and as we know when we go to the doctors, you better have some kind of a HIPAA document regarding the privacy of your medical information.
So you said a will or a trust. Yeah. How does somebody know if they need a trust?
That's a great question.
Really fairly circumstance specific, isn't it?
Absolutely. I think what we're seeing, people who choose a will opposed to a trust, and you can have both in this situation. People who pick a will is they don't have issues or circumstances like we'll talk about that dictate a trust. But if you have a house, as we talked about, a car, jewelry, and there's some reasons, my guardianship. I mean, now that will work both for a will or trust. Minor children that you want to leave a guardianship, a person who will take care of it, so you don't have issues in the past. And we need to chat on that about a guardianship opposed to having a trust on that.
Okay, but circumstances where someone might need a trust would, I think the obvious is not everyone's good at handling money, and so to protect a child and make sure they have funds for the rest of their life. Absolutely. There's also some bloodline conversations that come into that as well for people who might not want an inheritance to end up outside of the bloodline.
And you see that with second marriages, third marriages going on the line, that they want to protect the children from the first marriage. And a lot of times couples are concerned as they get older, if the first to die, the second one may be taken advantage of, and so if it's put into a trust with a trustee, whether it be an individual trustee or a corporate trustee, as a Caldwell Trust Company does, they feel that they'll be protected against individuals.
So the vulnerability.
Absolutely.
Yes. Okay. In the bloodline also, I know that one of the things we hear is sometimes the children's marriage is not as stable as the parents would want, and so making sure again that the money stays in the bloodline, leaving that money in trust for that.
Absolutely.
And then also there are certain special needs children where there's public benefits or something that it's important to make sure that you don't disqualify them, and a trust is appropriate there, I think, as well.
Absolutely. And what we're seeing a lot more too is elder care attorneys, whether they're creating special needs trusts or they're protecting them from Medicaid. And so there are specific trusts. I believe that they're creating that are Medicaid type of trust, that they're fearful either they're going to run out of money or the second surviving spouse would not be protected.
Okay, that's a good point. You mentioned the G word, guardianship.
Oh boy,
that,
yes.
That puts fear in the hearts of everyone.
Right.
How does someone end up in a guardianship?
Well, probably not pre-planning documents that could happen. So an individual becomes incompetent. Family members maybe perhaps circle around the doctor who indicates that they are no longer able to handle their financial means. If you have language in a trust, and it's an ongoing trust, it will probably outline what they would need to do so that you don't go through a guardianship, because as we all know, guardianships are extremely expensive. There's many attorneys that are involved, and it is to protect the individual, of course, but it's somewhat of a costly experience. There are accountings that have to occur annually, and so I think no wonder people are concerned about that you need to put that in a trust. I want to make a point on that when we're talking about wills and trusts. I thought that was interesting is a will doesn't become effective until you pass away, where a trust would be effective the minute that you sign the document. So key point though is, let's take it as we were chatting about titling of assets. You can do a trust, sign it, it becomes effective. As we know, there's a grantor, the individual who creates the trust, and the trustee. That may be one and the same, as long as you're competent, or you maybe naming a family member or a corporate trustee. It becomes effective. Now, it's very important that you title your assets into the trust, because you can have a well-written trust, but if there's nothing that's titled in the name of the trust, then it will not pass according to your wishes, will perhaps be in your own name.
We've seen examples of that for years, where people had all the right documents in place, but they didn't finish the plan by changing the titling of the assets into the trust.
Absolutely.
And it makes the plan pretty ineffective.
I agree. The other thing is that regarding the titling of assets, and we chatted again about this as well, is there are other things that will not pass through your will or your trust. An IRA that has a beneficiary designation, annuities usually have beneficiary designations, joint trusts, payable on death, transfer on death. Those are all things that will pass according to those beneficiary designations or the way that they're titled.
So really a trust isn't a matter of how much money a person has. It's really much more a matter of the circumstances in their family and what they're trying to accomplish.
Correct. Most planners will suggest when you're 18, that's the time to do that. You may not feel like you have much, but even as simple as a car title is somewhat cumbersome if you don't dictate who it goes to in a will. Retirement, you may be working at a company and have a small 401k. Again, if you don't designate someone, you're 18 years old, you really don't feel like you have anyone to designate it, it will flow through your will, and you'll be able to select who you want. If in fact you die, as they call it, intestate, without any documents, without a will, then unfortunately the state's going to dictate where your assets go to according to how it's outlined.
I can't imagine anyone would want that.
No,
so,
I agree.
And the expense of actually letting the court decide and the state decide where you wanted your money to go anyway is just an unnecessary expense and an unnecessary delay.
Another confusion that kind of reminded me what we're talking about, will, living will. Why don't you explain a little bit of the difference, because I think people kind of sometimes confuse the two.
Right. Will is really last will and testament. That is my wishes upon my death. As you said, it doesn't come into play until the person passes away, but those are the wishes that they want, how their assets are to be distributed and how their estate is to be handled. Living will is really the designation of under what circumstances and what heroics, if you will, you want performed to save your life. So there's a DNR, which many people in nursing homes have, which is do not resuscitate. That's really the extreme version. A living will is really whether or not you want some life-sustaining measures. I have fallen and I have lost my breath and I want to be resuscitated, versus I have a terminal injury and
I don't want to be put on a
respirator or life support systems. So a living will allows a person to make those selections during their lifetime of what type heroics they want performed to save their life.
And at the end of the day, it really helps the family out knowing what those wishes are, because those are not decisions that sometimes you want to make for your loved one.
And I think that's a great place to wrap up. All of this is extremely helpful to the family because you know what Mom and Dad wanted, and you're carrying out their wishes, which can also save some internal feuding over what Mom wanted or what Dad wanted when they've written their own plan.